Quick question. You get your green card, you live in New York for 5 years, you make a quick trip to visit family overseas, you come back to JFK, and instead of waving you through like always, an immigration officer stops you, doesn't admit you, and calls it a parole.
Wait, a parole? Like I committed a crime?
Here's the thing. In immigration law, parole doesn't mean what it means in criminal law. It just means the officer let you in temporarily, without formally admitting you. And that distinction, it could get you deported.
That's basically what we're talking about today in Bondi versus Lau.
Let's say you're Muk Choi Lau. You came to the United States in 2007, got your green card, built a life in New york with your family. Then in 2012, New Jersey charged you with trademark counterfeiting, specifically selling $282,240 worth of counterfeit apparel. Charges pending, no conviction yet. And you took a brief trip to China.
Okay?
You come back to JFK in June 2012. The FBI records check flags your pending charge. An immigration officer decides, I'm not going to admit you. I'm going to parole you in for a deferred inspection.
What does that mean practically?
It means the officer kicked the can down the road. You get in, but your immigration status stays frozen at the border. You're technically still seeking admission. And here's why that matters. A lot. Because which track they put you on determines who bears the burden of proof.
Exactly. And that's the fight at the Supreme Court?
Welcome back to the High Court Report. Today we're digging into Bondi versus Lau, a case about green cards, airport parole decisions, and whether the government gets to choose the rules of the game after the fact. The court hears oral argument on April 22nd. It's now actually called Blanche versus Lau, but Bondi or Blanche versus Lau, same case. Quick reminder, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. All right, here's what you need to know.
Here's what the Supreme Court must decide. Whether to remove as inadmissible a lawful permanent resident who committed an offense listed in the immigration statute and got subsequently paroled into the United States, the government must prove it possessed clear and convincing evidence of that offense at the time of his last reentry.
Okay, in plain English, that means, does the government need to hold proof of a crime in its hand at the airport? Or can it prove the crime later in a courtroom? And there are two totally different removal tracks under the Immigration and Nationality Act, the INA. One track covers people the government calls inadmissible. The other covers people already admitted who later get deported. Those sound similar, but they operate very differently. On the deportation track, the government carries the burden. It must prove by clear and convincing evidence that you did something wrong. On the inadmissibility track, the burden flips. You have to prove you're entitled to enter. So the government choosing inadmissibility instead of deportation, that's not a technicality. That's a tactical choice that determines who has to prove what.
And here's the key statute. The INA says a lawful permanent resident, a green card holder, shall not be regarded as seeking an admission into the United States when returning from a trip abroad, unless one of 6 exceptions applies. Exception number 5, the LPR has committed an offense that triggers the inadmissibility grounds. That's what this case turns on. And the parole authority, that only applies to someone applying for admission. So if Lau doesn't count as applying for admission, the government didn't even have the power to parole him.
Which brings us to the fight.
Let's tell Muk Choi Lau's story because the timeline here matters a lot.
Lau came to the United States in September 2007 as a lawful permanent resident. He settled in New York. He lived there with his family for 5 years. Then in May 2012, New Jersey charged him with trademark counterfeiting, selling apparel with counterfeit marks, allegedly worth $282,240. While those charges sat pending, no trial, no conviction, no guilty plea, Lau traveled briefly to China.
And he came home.
He came home June 15, 2012, JFK Airport. An FBI records check turned up the pending criminal charge. An immigration officer made a call. Don't admit him. Parole him in instead for a deferred inspection. Now, here's what that meant. Lau walked out of the airport. He got to live his life. But legally, immigration authorities treated him as if he never actually crossed the threshold into the United States. He stayed frozen, in their eyes, as an arriving alien waiting for his inspection to complete.
And then he pled guilty.
June 24th, 2013. More than a year later, Lau pled guilty to trademark counterfeiting in New Jersey Superior Court. He received 2 years probation, no prison time. In March 2014, the government initiated removal proceedings, not under the deportation track, but under the inadmissibility track, arguing Lau's conviction proved he committed a crime involving moral turpitude.
Okay, pause. Let's break down what moral turpitude means. It's an old legal term covering crimes that reflect dishonesty or moral depravity, fraud, theft, counterfeiting. The courts long ago classified counterfeiting as a moral turpitude offense.
The immigration judge and the Board of Immigration Appeals both said, removal order stands. Both ruled against Lau. Then the Second Circuit Court of Appeals, a unanimous panel, reversed. Judge Sullivan wrote that the INA required the government to possess clear and convincing evidence of the disqualifying crime at the moment Lau arrived at the airport in June 2012, not afterward, at the border. When Lau returned with only a pending charge, not a conviction, the government lacked that evidence. So the parole call lacked authority. And if the parole lacked authority, Lau got admitted by default. And once admitted, only the deportation track applies. The Second Circuit denied en banc rehearing. Every active judge either agreed or stayed silent. And the Supreme Court granted cert on January 9, 2026.
Which brings us to the arguments. The government argues the INA expressly strips courts of jurisdiction to review discretionary parole decisions. Section 1252 of the INA says no court gets jurisdiction to review any decision or action in the discretion of the Secretary of Homeland Security. The government says Lau got paroled. That's a historical fact. Courts can't rewind it, can't relabel it as an admission, can't second guess it. Full stop. The government makes a comparison here that I found striking. It says an improper parole decision resembles a wrongful criminal conviction. A defendant might argue the prosecution's evidence didn't meet the legal standard, but the conviction still stands until properly overturned. Likewise, Lau might argue the immigration officer lacked authority, but he still got paroled.
And because the parole stands, Lau legally stayed an arriving alien awaiting inspection through his entire removal proceeding. The INA says it clearly. An arriving alien remains an arriving alien even if paroled.
The second government argument, even if courts review the parole decision, the government needed only to prove the offense at the removal hearing, not at the airport.
The INA directs that removal proceedings decisions shall be based only on the evidence produced at the hearing. Lau's 2013 conviction judgment conclusively proved he committed the counterfeiting offense in March 2012, before he ever returned to JFK. The government argues litigants prove historical facts using later created evidence all the time. A citizenship affidavit in a federal case, an expert psychiatric report for an insanity defense. This isn't different.
And the government's third argument, the Second Circuit's rule defies history and practical sense. For 134 years, since 1891, Congress required border officials to screen out non-citizens who committed crimes involving moral turpitude. The government argues requiring line immigration officers at high-volume airports to conduct mini-trials weighing clear and convincing evidence before exercising discretionary parole authority would break the border inspection system. Those officers aren't lawyers. They handle enormous volumes of travelers and must make quick calls. The practical effect of the Second Circuit's rule, the government says, would nullify parole for green card holders entirely.
Here's where Lau's side gets genuinely interesting. His team argues the government's position collapses into a logical circle. Let me lay it out. The government can only parole someone applying for admission. Lau, a green card holder, only counts as applying for admission if one of 6 statutory exceptions applies. Exception 5 requires that he has committed a disqualifying offense. But to establish that exception, the government needs clear and convincing evidence of the offense, which it didn't have at the border. So the government tries to parole him to determine whether it had the power to parole him. His brief actually uses a great line here. It says if the government's logic worked, all we'd have to do to fly is reach down and tug on our shoes to find we had Hermes' winged sandals. Bootstrapping your way to authority by exercising authority you don't yet hold.
And Lau's second argument, courts absolutely retain jurisdiction to review this. The INA preserves judicial review of questions of law even for discretionary decisions, and the Supreme Court confirmed in Wilkinson v. Garland, that's a 2024 case, that courts can review whether a non-citizen was statutorily eligible for a discretionary action, whether the government held the authority to parole Lau at all. That's a question of law.
Lau also distinguishes the government's conviction analogy. Courts carry independent constitutional authority to enter judgment. DHS only holds the powers Congress gave it. An unauthorized parole isn't like a wrongful conviction. It simply never happened as a matter of law.
The third Lau argument. The government always held ample authority under the deportation track, and 134 years of border practice actually supports his position.
This one's sharp. Lau points out the government's public safety complaint doesn't add up. Parole let Lau into the country regardless. The only question, which removal statute applies? And under the deportation track, the government can still remove Lau if it proves his conviction. Losing the inadmissibility track doesn't mean losing removal authority altogether. Escaping inadmissibility, as the brief puts it, does not mean escaping deportation.
And on the administrability concern, Lau notes that immigration officers already check for crimes involving moral turpitude at the border every single day for everyone else. They run criminal history databases, ask about prior offenses, review conviction records. If they could do this assessment in the era of wooden ships and oil lamps, before computerized databases, the argument that it's too hard today doesn't hold.
So what does this actually mean for real people? If the government wins, the Supreme Court reverses the Second Circuit. DHS keeps the ability to parole returning green card holders facing criminal charges and use the later conviction to justify that parole retroactively. The inadmissibility track stays available whenever the government chooses to use it. The burden of proof stays on the non-citizen. And importantly, the government preserves flexibility to let LPRs in while criminal cases play out without forfeiting removal options, which the government argues actually benefits LPRs too. Under the current practice, Lau got to organize his criminal defense from inside the United States for over a year before his guilty plea. If the Second Circuit's rule stands, the government claims it would instead feel pressure to initiate removal proceedings immediately, which could mean detention.
If Lau wins, the court affirms the Second Circuit, the government must prove the disqualifying offense at the moment of reentry. No conviction, no clear evidence in hand. The government admits the LPR, and from that point forward, only the deportation track applies, with the government bearing the burden of proof. For Lau specifically, the case returns to immigration court for proceedings under the deportation statute. His removal isn't off the table, but the government has to prove its case the harder way.
And for every green card holder who travels abroad with a pending criminal charge, which describes a not insignificant number of people, this case determines whether a border officer's in-the-moment parole call, made without a conviction in hand, can lock them into the inadmissibility track years later.
The stakes look different depending on which table you sit at. For DHS, this touches every port of entry decision involving an LPR with a criminal history flag. For returning permanent residents, this determines whether they get the protections that come with admission or whether a split-second airport decision freezes them in legal limbo indefinitely.
Watch for questions at oral argument about the circularity problem. Lau's logic, you can't parole to determine whether you can parole, poses a genuine structural challenge that the government never fully answered in its brief. Justices will press hard on that. Expect justices to probe the jurisdictional question sharply. Wilkinson versus Garland came down in 2024 and held courts can review statutory eligibility for discretionary decisions. The government needs to distinguish that precedent, and it won't find that easy.
Watch Justice Barrett and Justice Jackson on the present tense textual argument. Lau leans heavily on the word seeking, present tense. As proof, the assessment must happen at the border. Whether the textualists on the court find that persuasive will likely determine the outcome. And watch for questions about what happens to the other five, Section 1101, A, 13, C, exceptions under the Second Circuit's rule. The government argued border officers will almost never hold clear and convincing evidence of illegal activity abroad or LPR status abandonment at the time of arrival. If the court accepts the government's concern for those exceptions, Lau's reading might create a problem the court doesn't want to create.
Bottom line, time. Why does this case matter?
Because it answers a question with enormous practical stakes for millions of green card holders. When the government decides to invoke the inadmissibility track instead of the deportation track, does it need the goods in hand, or can it fill in the proof years later?
Two different legal frameworks, two different burdens of proof. One airport decision made in seconds that could determine the outcome for a 69-year-old New Yorker who received 2 years probation.
We'll cover the oral argument and the decision when they come. Keep watching. That's it for today's episode. Find us on Apple Podcasts, Spotify, YouTube. Search the High Court Report. Talk to you soon.